contempt of court in India. What is contempt of court and what is the constitutional basis of this one? Everything we'll be discussing now. The context is why we are discussing this topic is, or the context of recent controversy is recent alleged derogatory remarks against the Chief Justice of India and the Supreme Court have raised concerns. What is it? Such comments, especially spread via social media, may erode public trust and obstruct justice, forming grounds for contempt proceedings. What happened was recently, even the slippers were thrown at the Chief Justice of India, that is B.R. Gavai, because of his remarks on a temple. Okay, so there is a reduction, or there is a trend in India where the reverence that the Chief Justice of India and Supreme Court used to enjoy is on the low. Okay, next, this issue highlights the balance between free speech and the respect for judicial authority. Just because you have free speech doesn't mean that you can make derogatory remarks against judicial authority. That is what the article argues about. What is the constitutional basis? Constitutional basis for the free speech is obviously Article 19 clause 2. It provides freedom of speech and expression. That is, and also Article clause 19(2) puts certain reasonable restrictions on this free speech, allows reasonable restrictions on free speech for contempt of court. And in Article 129 and 250, it declares that Supreme Court and High Courts as the courts of record, meaning any judgment or any record that is given by the courts of Supreme Court or High Court can be used as a precedent by the lower courts. Next, a court of record means judgments are preserved as evidence and it has inherent power to punish for the contempt as well. Next, the constitutional power is elaborated by the Contempt of Courts Act in 1971. Under this contempt of the court, there is one more provision. The judiciary has upheld that the contempt of court doesn't only mean to Supreme Court or High Court, but also the contempt of lower judiciary as well. Okay. Next, types of contempt. In contempt, there are two types. One is civil contempt, another one is criminal contempt. What is civil contempt? It is mentioned in section 2B of the Contempt of Court Act of 1973. It is willful disobedience of a judgment, decree, order, writ, or breach of an undertaking given to a court. I will give an example. So the court has already provided a judgment, that is there is a willful breach of undertaking as well. That is, a person will be giving an undertaking that I will go to so and so police station and I have to give my thumbs now and then. So that is the undertaking given to the court. But now if he refuses to go there and give his thumbnail or give his thumbprint to a particular institution or particular police station, then he is contempt in the court, and that contempt of court is civil contempt. Okay. And again, if there is a judgment, for example, the Supreme Court has already provided a judgment that women are allowed to enter into Sabarimala court. Now, if a person is willfully disobeying it, meaning if he is not allowing a woman to go into the judgment, go into the Sabarimala temple, he is violating the contempt of court, but that is civil contempt. Next, criminal contempt, section 2C. What is the criminal contempt? Publication or act which leads to, scandalizes or lowers the authority of any court, prejudices or interferes with the judicial proceedings, or interferes with the administration of justice. For example, if the scandalizes or lowers in the authority of High Court, recently, like almost 4 or 5 years back, there was an incident which happened in High Court of Hyderabad. What happened was, instead of, there was an argument in the court and the court has provided a judgment. So in reaction to that, a person in the court showed his finger next to this one, that is the middle finger next to this one. He showed up middle finger in the court and he was put with the contempt of court charge, that too a criminal one, because he scandalized or lowers the authority of court here. Next is prejudices or interferes with the judicial proceedings. So normally you might have seen in the old movies of Kannada, where the judge himself is kidnapped. So the kidnapping of the judge or interfering in the judicial proceedings comes under willful disobedience. Criminal contempt, and interferes with the administration of justice, that the court has already provided some judgment and you are not allowing that judgment to be carried out. It is also amounts to interference in the administration of justice. These three come under the criminal contempt of court, and this willful disobedience and breach of an undertaking come under civil contempt of the court. Next, hence, contempt is more than mere disrespect. It covers acts threatening judicial independence or justice delivery altogether. Next, Procedure for initiation. How do you initiate this contempt of court procedure? First, proceedings may be suo motu by the Supreme Court or the High Court. Okay, suo motu in the sense the courts are taking the case by themselves. Then, or by a third party with the consent of Attorney General for the Supreme Court or Advocate General for the High Court. Okay. Next, judicial interpretation and the key cases. There have been various cases about the contempt of the court. First is Ashwini Kumar Ghosh versus Abhinandan Bose of 1952. In this case, the court held that fair criticisms of the judgments is not contempt. Okay, court has given a judgment. If a person is criticizing the judgment fairly, without any intent to derogate or without any intent to lower the respect for judiciary, then it should not be considered as contempt of court. Only unfair, malicious or scandalous attacks qualify as contempt of court. Very important, remember this judgment. In case there is a mains question about the contempt of the court, this case is very important to argue against contempt of court in the analysis. Next, Anil Ratan Sarkar versus Hirak Ghosh 2002. Here, the court held that power to punish for contempt must be used cautiously and sparingly. And next, in M.V. Jayarajan versus High Court of Kerala. In this case, abusive public speech against the High Court order amounts to criminal contempt itself. And finally, in Shanmugan at Lakshmi Narayanan versus High Court of Madras. That is, purpose of contempt power is to uphold the administration of justice and not individual judges. Okay, so recently there was a case. Judge went outside and attended RSS meeting. So there was a criticism against the judge, and judge wanted the contempt of court. But many held that you are not lowering the Supreme Court or High Court here. You are just only criticizing the individual judge. So individual judge does not mean contempt of court itself. Next, limits of criticism. That is, constructive criticism of the court action is permissible in democracy. So just because you are a judiciary and just because you have the authority of the Supreme Court or High Court doesn't mean that your work cannot be criticized. Many people criticize the work of judiciary so that there is lots of pendencies. Such fair criticism or constructive criticism should not be considered as contempt of court, especially in a democracy like India. Next, however, misrepresentation, falsehoods or personal attacks can damage public confidence, violate constitutional morality, and undermine judicial independence. Though these are not covered in contempt of court, they still lead to these kind of things. This is one of the limits of criticism. Next, what is the broader democratic implications? That is, judiciary's credibility ensures rule of law and substantive justice. Next, misuse of speech that diminishes judicial authority threatens democratic principles and citizens' faith and justice. So, contempt of court is very essential in a democracy like India, so that the respect and the reverence that the judiciary demands must be maintained. A very important article and very beautifully explained as well.